conjunction with its issuance in April 2016 of the fiduciary rule, the Department of Labor amended a number of existing prohibited transaction class exemptions that are frequently used by financial services companies when serving retirement plans. The DOL determined that additional conditions should be imposed on the availability of each of these exemptions in order to adequately protect plans and IRAs. In each case, the DOL has imposed a so-called impartial conduct standard that must be satisfied for the exemption to be available. So to meet this new standard, the following requirements must be satisfied by the fiduciary. A, the fiduciary must act in the best interest of the client. The fiduciary must satisfy the prudent man standard without regard to the financial or other interest of the fiduciary or its affiliates. B, the aggregate compensation received by the fiduciary and its affiliates must be reasonable. And C, the fiduciary statements about the transaction, fees and compensation, material conflicts of interest, and any other matters relevant to the plan's investment decisions must not be materially misleading. So these standards will now be a condition to a prohibited transaction exemption. From a litigation context, the burden of proof now shifts to the defendant fiduciary from the plaintiff. So how does a fiduciary prove implementation of an impartial conduct standard? FI 360 has published handbooks, prudent practices for investment advisors and stewards, which are substantiated in law. And CEFEX performs assessments which verify adherence to these practices, resulting in CEFEX certification. So by achieving CEFEX certification, fiduciaries can demonstrate they are acting in the best interest of investors, plans, and plan participants. Our assessment also covers the review of reasonable compensation and the fiduciary statements to plans and IRAs. Upon certification, we provide a legal opinion from the firm Drinker, Biddle & Reith, which states that the certified firm is demonstrating adherence to the impartial conduct standards. Our certification, combined with this legal opinion, can be a compelling defensive regulatory strategy for the firm with respect to the new rule.